public places. Before we begin, I would like to thank President Docking, Vice President Rebar, Dean Milner, and the faculty at Adrian College for supporting our institutes and our programming. I would also like to thank Professor Nathan Getting for organizing this debate. Special thanks also to the Romney Institute interns, Giovanni Esquivel and Nicole Darish, whose good work made this debate possible. In 2008, in DC, v. Heller, the United States Supreme Court issued a ruling on the Second Amendment. The court held that the Second Amendment protects an individual's right to possess firearms in the home for self-defense. Now, the Supreme Court will consider the question of whether the Second Amendment protects the right to carry firearms in all public places. Our speakers today will address this question and consider its moral and legal implications. Our first speaker is Richard Broughton. He is Associate Dean at the University of Detroit Mercy Law School. He's a well-known constitutional scholar with many publications on the Second Amendment. Dean Broughton served in the Criminal Division of the U.S. Department of Justice in Washington, D.C. His work involved federal prosecutions of violent crime related to gang activity, drug trafficking, organized crime, and racketeering. He also has served as Assistant Attorney General of Texas for capital and post-conviction litigation. Our second speaker today is Professor Stephen Dulan. Professor Dulan is a practicing attorney and has taught college courses on the Second Amendment, firearms law, American federal government, homeland security, mock trial, and others for over 20 years. Professor Dulan has also filed a brief with the U.S. Supreme Court on whether there is a constitutional right to carry firearms in public. Our debate format today is as follows. Dean Broughton will have 10 minutes to argue that the state can and ought to ban firearms in public places. Then Professor Dulan will have 10 minutes to argue the other side. This will be followed by a 5-minute response from Dean Broughton, and then by a 5-minute response from Professor Dulan. During the last 20 minutes, I will invite you to challenge the speakers with thoughtful questions that will push them to provide a more robust defense of their views. The event will end at 12:50. Our debate series and today's debate are a commitment to meeting a challenge. This is the challenge of conducting discourse with civility and of supporting academic freedom and freedom of expression. We do this because it matters a great deal. We are committed to open and rigorous discussion of controversial issues on our campus. Issues regarding firearm possession, carry, and use are ones of profound disagreement, and it's precisely such issues that we should be able to discuss openly and fearlessly. The great Aristotle pointed out that it is the mark of a truly educated mind to be able to entertain an idea without having to adopt it. This is what a calm, rational person ought to be able to do to discover the truth. Behind this is the Socratic ideal that open debate is the way to truth and to the good life based on truth. We exchange ideas in dialogue, we can think more clearly for ourselves, and then we can live better lives. Socrates taught us that a strong and just society is one in which people can discuss controversial matters rationally without resorting to anger or violence. I'm confident that today's debate will show that we can rise up to the challenge and that we can live up to the Socratic vision. Please join me in welcoming Dean Richard Broughton.
Well, thanks very much. It's nice to be here with you. It's my first time at Adrian, so happy to be here. It's nice to see Professor Getty, who I've known for a while and who does tremendous work. And it's also nice to see Mr. Dulan, who is a very experienced voice on these issues and whose work is worthy of much respect. Of course, the issue that we're discussing today is one of real public importance, and it's become all too familiar to discuss gun rights as if there's no middle ground. And if you appear to take the middle ground, you're somehow sort of wishy-washy on the issue. So we end up, as we do in a lot of other areas of law and public policy, at the extremes, where nuance and complexity are avoided. The problem is, that's not the real debate. right? The real debate is filled with nuance and complexity. Gun rights are real. We have a rights-bearing constitutional amendment. It has been interpreted to protect individual rights to possess guns in the home for self-defense. Moreover, we often talk so much about the Second Amendment that we forget that it is not the only source of gun rights. State laws are free to grant broader rights grant broader gun rights that are available under the Second Amendment to the Constitution. And some state laws are incredibly liberal in permitting gun ownership and possession. At the same time, we have extensive gun regulation in this country. We have regulations on commercial sale, we have background checks, we have regulations on who can possess firearms, we have regulations on the firearms themselves and ammunition. Now we can debate the virtue or even the legality of those regulations, but the point is we live in a country with both liberal gun laws and extensive gun regulation. So the bottom line is that gun rights absolutism on either side misses the point. The real question is, in a country with gun rights, what is the permissible extent of gun regulation? And that's what we're going to talk about today. Now, I suspect there are areas on which Mr. Dulan and I disagree, but I also want to make sure that I emphasize some points where I think we might agree. First, I suspect that Professor Dulan and I agree that the Second Amendment protects an individual right to keep and bear arms. The Supreme Court determined this in the Heller case, that the amendment does not apply only in the context of malicious service, but rather is a right enjoyed by individual law-abiding citizens. I think that's correct. But, like every other constitutional right, the right is not unlimited. So the kinds of extremes that we see in the Second Amendment debate, which talk about any regulation of firearms as if it fails constitutional scrutiny, is simply not correct. Heller recognized as much. And one of the limits that the court recognized in Heller was that the right to keep and bear arms did not cast doubt on presumptively lawful regulations of guns, including firearms in sensitive places. And I'll address that more specifically. Second, I suspect that Professor Dulan and I agree that the core of the Second Amendment is the right to keep and bear arms for self-defense. Again, I think that's right. But too many Second Amendment advocates discuss this concept at a level of generality or abstraction that is far too high. Understood at that level of generality, the natural right of self-defense, you hear argued, virtually all regulations of firearms would be unconstitutional. So I think that if we are to understand the Second Amendment with reference to its original understanding, and therefore with reference to the history and tradition, not only of the Second Amendment, but of gun regulation in America, then the Second Amendment's meaning must account for the law of self-defense as it existed at the time of the Second Amendment's adoption. And that law was far more restrictive than much of modern self-defense law. For example, self-defense requires a reasonable belief that the use of force is necessary to protect against the imminent use of force by another. It also requires proportionality. You cannot use deadly force to meet non-deadly force. But perhaps most importantly, the common law of self-defense, that is the English law that would have been known to the framers of the Second Amendment, required a person to retreat to a place of safety before he or she could use deadly force in self-defense outside of the home. Now, inside of the home, something called the castle doctrine applied. You do not have to retreat to a place of safety when you are inside of your home. But outside of the home, unless retreat to a place of safety is not possible, one could not use self-defense, could not use deadly force in self-defense, absent an effort to retreat. That is because self-defense is, at its core, a principle of necessity. If the occasion for the confrontation can be averted, it must. Otherwise, there is no necessity. Now, if the Second Amendment is to be understood with reference to self-defense, if it is coextensive with self-defense, then we must account for these limitations in the law of self-defense. And while retreat is not required in every circumstance, it would at least limit the circumstances under which a person would be privileged to use deadly force outside of the home. So when we're talking about guns outside of the home, the concept of self-defense does not do all of the work that gun rights supporters seem to think that it does. And anyone carrying a gun in a public place who is looking for or seeking to provoke a confrontation, or is unwilling to take reasonable steps to safely avoid a deadly confrontation, is actually operating outside of the very tradition of self-defense that they claim to be defending. Finally, third, I suspect Professor Dulan and I agree that notwithstanding these limits on self-defense, there remains a role for self-defense outside of the home, and I agree that the Second Amendment extends beyond the home. I'm confident that the Supreme Court will say this in the New York State rifle and pistol case. But again, speaking at that level of abstraction is ultimately unhelpful. Because in my view, the question is not whether the amendment has application beyond the home, but whether the government may restrict guns in certain places. And I think it can. The Supreme Court has already said this. And with good reason. There is a long and unbroken historical tradition of limiting guns in public places and private spaces beyond the home. The court identified schools and government buildings, but those were only examples. Think airplanes, churches, child care centers, college campuses. Think of legislative bodies, the White House, even the Supreme Court itself. Both English law and a number of jurisdictions in early America, and most every jurisdiction today, prohibited guns in certain locations at certain times. Now, the idea here is one of public safety, of course. It's one of preservation of life, of course, but that's not all. It's also a recognition of values embedded in these particular places, in legislative chambers, in schools, in churches, in courthouses. These are places where the activities being performed are best done without the threat of armed coercion and the possibility of disruption of those important activities: self-government, civic education, study, discourse, worship. Right? Not at the barrel of a gun, which can cause terror and chill the relevant activity. Even the counsel for the New York Rifle and Pistol Association acknowledged the constitutionality of sensitive place limits during oral argument in the case. Counsel argued that a sensitive places regulation is different from the kind of regulation that New York is imposing in this case. He even conceded in a question from the Chief Justice that guns could be restricted on college campuses. Even Justice Barrett said that counsel had to concede that historical evidence allowed regulation in sensitive places. Now, there are opponents of the so-called gun-free zones, and they have a sensible claim. The need for armed self-defense could potentially arise anywhere. And many of the places where guns are forbidden are the very places where the need for armed self-defense might be the most acute. That is particularly true when you consider that the bad guys aren't really going to care that guns are prohibited. I get it. So it's sensible to wonder whether citizens might be better protected if they aren't legislatively disarmed. If I were a legislator and I can give greater rights through legislation than under the Constitution, I might be persuaded to limit gun-free zones. But that policy argument is different than the constitutional argument. And the idea that the Second Amendment categorically forbids these gun-free zones or sensitive places is not consistent with the court's decision in Heller, and is not consistent with the very laws that would have been known to the framers of the Second Amendment. As a historical matter then, and as a matter of the original understanding of the Constitution, I believe that the state is not commanded to allow guns everywhere.
Thank you, Dean. Well played. We certainly found some areas of agreement. One of them is want the world to be safe. We want to be safe everywhere we go, right? We just have a disagreement about how to get there from here, and what's the best way to accomplish that. And there are really two different issues that the dean raised. One is, can I be prepared to defend myself? And the second is, when may I defend myself, right? Because if you have disarmed me when I go someplace, because I chose to go there, I'm disarmed, then I'm not prepared to defend myself, right? There was a time, I was a young infantry sergeant, I was well-trained and in good physical condition, and I didn't feel like a gun was necessary for self-defense, even if there were more than one attackers, right? Probably I was wrong, but things change, right? So as I get older, I realize tools are helpful. And what is a gun? It's a tool for punching holes in things at a distance. That's ultimately what a gun is. And the reason that guns have been so demonized over time has more to do with politics than actual practical public safety. Because when there's a so-called crime wave, politicians find it easy to demonize the gun. To say, oh, guns are bad, if we could just get rid of the guns, that somehow we'll all be safer. Two problems with that argument. First, you can't get rid of all the guns. I think that's the most important one. Pandora's box is open. We don't even know how many guns there are in the United States. Estimates range from 300 million to 800 million. And they both have pretty decent methodology on their guesstimates, right? So we don't know. And in my opinion, that's a good thing. And so something I certainly agree with the dean on is you can't stop the bad guys, right? So I'm sitting here, or standing here in this classroom on a college campus, and some of you might not remember because it was a few years ago, but one morning at Virginia Tech University, an individual named Cho decided for whatever reason, and he gave many, but none of them probably made sense, I'm sure they didn't to me, decided to just go kill a lot of people on a college campus. Now they had a no guns regulation on that campus, right? And so nobody shot back at Mr. Cho as he just wandered from building to building too. It wasn't just in one place. And all anybody could do was kind of hide and hope to block the doors and hope, basically, right? Well, hope is not a good plan, it turns out. So a lot of people got murdered that day by this crazy individual. Granted, that doesn't happen very often, but you certainly don't make things safer by disarming me or you, because I'm not afraid of anybody in this room either. And I'm not because I can beat you in a fight. I mean, I'm not afraid of you suddenly whipping out a gun and shooting me, because I'm not armed today, or am I? You don't know. That's my point. Actually, I'm not. There's rules here, right? But you don't know if I am. And because, and here's the other big distinction that we have to make, between sensitive places, so-called, and public spaces, a lot of those sensitive places the dean listed have magnetometers at the entrances and armed guards, right? So airports, we'll use that one. I go into an airport, I'm not armed. It's one of the few places. Courts, airports, these are some of the few places I'm not armed. So I, like about 700,000 other people in Michigan, have a concealed pistol license. And so I'm typically armed for a variety of reasons, one of which is how embarrassing would it be to not have it when I needed it, right? I just don't want that to come up in my obituary. Well, guess what? He got shot by a guy because he didn't have his gun with him. Considering some of the positions I've taken publicly, that would be really embarrassing. So that's one of the big reasons, honestly. I don't want my kids to be embarrassed if I get shot somewhere. But here's the thing. Everywhere I go, myself is there, right? So if the core of this right is self-defense, and myself goes someplace, and there hasn't been some provision made for my safety with magnetometers and armed guards, then I'm being made to be vulnerable by the state to give up my ability to defend myself with no assurances, right? Because, and we'll keep it on the practical level, because I agree with you, actually, we don't want to keep it too highfalutin, right? My brother's a medically retired cop, and every once in a while he comes up with something really smart. Don't get me wrong, I tease him a lot. I say things like, I'm the brother who can read, stuff like that, right? But he comes up with some really smart things, and one day he said, It's after a few years on the job as a Milwaukee police officer in a very violent neighborhood. My job isn't to save anybody. My job is to put yellow tape around your body and maybe find who did it. That's my job, right? So if you don't have actual armed security on the scene with metal detectors, then there's no safety there, as much as you might have an illusion of safety, right? So gun-free zones, and something else we agree on, gun-free zones are actually a magnet for multiple victim public killers and other types of crime too. Those are the ones that they're vanishingly rare statistically, right, admittedly. But they do happen, and other crimes happen in those places too, because criminals don't fear their victims. It's better, in my opinion, when the criminal, on a policy level, if we just make the policy, make it so that the criminal doesn't know whether the victim's armed or not, and doesn't know whether having 2 or 3 bad guys all together in a group are going to be sufficient or not. So there's the practical aspect of this, and then there's also just the basic law part. So we have to talk about Heller just for a second. How much time? Who's keeping time? How am I doing? Do I have 3 minutes?
You have 4 minutes.
Oh, good, perfect. All right. So we have to talk about Heller for a second. So we've got this U.S. Supreme Court decision from 2008, Heller versus District of Columbia. Fascinating case procedurally, and also fascinating in the sense that the court, the Supreme Court, has what they call prudential rules. They limit themselves to the actual case or controversy before them. And all the other plaintiffs except Crazy Dick Heller, he likes when I call him that. I've met him several times. I call him Crazy Dick Heller. Here's why. He was the only guy crazy enough to walk into the city hall at DC and bang his hand on the counter and say, I want a pistol license. Because the rest of them didn't bother. They knew they couldn't get one. So when they drafted all those documents, they said they were chilled from trying. They got kicked out on standing. So the last guy left was Crazy Dick Heller, because he was the only one who physically went down there and demanded the license and was denied. He's an interesting guy in a lot of ways, but one way is his job is to be armed every day. Or he's retired now, but he was an armed security guard. They call them special police officers. And so what he had to do every day before he went home is take the gun that he was lawfully carrying all day and lock it up at the office and then go home and not be armed, right? Didn't make any sense to him. And that's why he pushed it, and he pushed it. He went to the Supreme Court. So the Supreme Court's limited on the facts. All they had was this person who's already allowed to be armed outside the home asking for the right to be armed inside the home. So that was the holding. That's it. That's the rule we got from that case, because those were the facts of that case, right? But something else we agree on is self-defense is the core, or at the core of the right. The Second Amendment definitely protects your right to protect yourself. Well, guess what? Yourself isn't home most of the time, right? So what about my right to protect myself when I'm not at home? Sure, great. The Heller case says I can have a gun at home, but that doesn't help me most of my days, because I'm not home most of my days, right? Just like you guys. So that's what the New York Rifle and Pistol Association case is about. And we put forth in the brief that I worked on for the Crime Prevention Research Center, we put forth a ton of statistical evidence and social science research showing that guns shouldn't only be legally allowed, but on a practical level they should be allowed. Because we too often we're faced with this false dichotomy. And we've had Supreme Court justices actually say it from the bench that there's this contrast between guns and safety. Turns out guns in private hands actually make things more safe, because the bad guys don't care. They'll show up and do whatever they want to do with their gun, whether it's rob you, assault you, kill you. And the only defense you've got in that moment is yourself and your gun. That's it. So the question is, do you have a right to be prepared to defend yourself? That's separate from when can I actually use my gun. But once you've taken my gun away, we never get to that second question, because I'm a victim. That's the end of it right there. Good? Okay, thanks.
Thank you very much. Robin, 5-minute rebuttal.
Thank you. There's a lot of sense in that. There's a lot of sense in that. Although I do have one question, right? So if the bad guys don't care about the gun prohibitions, do bad guys care that you might also be armed? I've worked on a lot of gun prosecutions and did a lot of work on gangs, for example. Wasn't clear to me that there was always a lot of concern that the other guy might be armed, right? And so we have to ask ourselves, do we want to, I'm sort of imagining this world in which everybody is armed because we just don't know if anybody else is armed, right? And I wonder if that's the kind of world that we want to live in. Now, certainly there's a lot of risk assessment here in the consideration of the issue. Look, risk assessment is inherent in life. Driving to work in the morning, flying on a plane to your vacation destination, playing football, right? Life involves risk. We determine on a case-by-case basis whether we want to assume those risks. And we try to assess, is the risk too high to engage in the activity? Is the risk sufficiently low that we would engage in the activity? But living involves risk. Now, to the extent that self-defense principles inform the meaning of the Second Amendment, it's important to remember that an undifferentiated interest in the potential for armed self-defense is not the same thing as necessity for purposes of self-defense. So I'll say that. But I would also say, although it is sensible to conclude on this view of risk assessment, that it weighs in favor of allowing guns most anywhere, because of the potential, which I suppose exists most anywhere, of the need for armed self-defense. My concern is that the argument that Professor Dulan makes assumes that the Second Amendment already makes that risk assessment decision for us, right? And puts the thumb on the scale of prohibiting gun regulation, right? Or disallowing guns in places beyond our own. I'm not sure that's right. First, that is not the position that the Supreme Court has taken thus far. So long as the place is a sensitive place, the prohibition on carrying in that place is presumptively lawful. And the very idea of presumptive lawfulness means we don't put the burden on the government to prove that it needs the regulation, right? Second, if we take the position that the Second Amendment has already performed the risk assessment for us, and it favors guns for self-defense because of the inherent or theoretical possibility of the need for armed self-defense, then it becomes difficult, if not impossible, to justify any of the limitations on the Second Amendment, right? For example, why limit the Second Amendment to common guns, right? There's a prohibition under Heller on dangerous and unusual weapons. Why? I mean, after all, these dangerous and unusual weapons might be better as defensive weapons, more effective, right? Why permit prohibitions for felons and the mentally ill? That's another limitation identified by Heller. Long-standing prohibitions on possession by felons and the mentally ill. Why? Don't those categories of people also have a need for self-defense? Don't felons have a need for self-defense? Don't the mentally ill have a need for self-defense? So in other words, the argument makes a lot of sense and is appealing on its face, but ultimately it proves too much. Now, as to what a sensitive place is, I think that's a fascinating question. I don't know if the Supreme Court's going to resolve that in the New York case. I think they'll have an opportunity to do so, but it's my view, and Professor Dulan may disagree with this, I don't think it's necessary to reach that question in order to resolve the issue in the New York case, but certainly the court could, and there was a lot of interest in that issue during the oral argument. Now look, I think it makes sense to say that not every place outside of the home is a sensitive place. Otherwise, there would be no need to single out sensitive places because they would be indistinguishable from anywhere else. So there is a possibility, in my view, that a sensitive places regulation could be over-inclusive. But the court hasn't settled on a test for this. Now, it might likely relate to the place's accessibility, the nature of the activity that occurs in the place, sensitivity to risk or public safety involved in that particular place. And it might, and Professor Dulan mentioned this, it might also have to do with the degree of security that already exists at the place. But once a place is deemed to be sensitive, Heller and the history of gun regulation, I think, suggests that there is deference to the government in deciding whether and how much to allow firearms in that place. Otherwise, I fear that what we're doing is we're enabling judges, especially unelected, life-tenured, salary-protected Supreme Court justices, to essentially devise a firearms code for us. And I fear that that would exceed their power as judges. So, now a lot depends on the framework for decision. We could establish categorical rules, we could establish contextual rules, but either way, if the regulation is presumptively valid, I think that it makes sense to give substantial deference to the government in deciding to regulate firearms there. Thanks.
Thank you.
There's the road. That's where we disagree. Deference to the government. I don't think that's what the Bill of Rights is about. I think this deference should be given to the individual. You should get to decide how you defend yourself. I don't trust the government to make rules and say, don't worry about it, we'll just let the police protect you, because they don't. End of story, right? So, turns out the smallest minority on earth is the individual. Each of us has to make a decision. We make a lot of decisions every day. You have to make a decision about how you want to defend yourself, if at all. And some people choose not to. Some people, I've got an aunt who says she doesn't believe in guns. I say, I assure you they exist, right? But she's never going to change her mind. She's never going to take the time to become that responsible gun owner. But the decision should be with the individual, not with the government. And the right to self-defense has to follow yourself wherever yourself goes. That's what I'm trying to say. Sensitive places, by the way, I have carried in the legislature in Michigan many times when I go down there to discuss bills, because it's totally fine in the Michigan Capitol. You can carry there. They changed the rules recently so that only those of us with concealed licenses can carry while we conceal. But I've carried in those places. There, as far as churches and some of the other places, schools, etc. The people who will obey those prohibitions are not the ones you have to worry about. So this fails on the basic philosophical terms, on the basic philosophical question of who has the right to decide how safe you are. Do you have that right? Or does some government bureaucrat who risks nothing get to make that decision for you? And most of them have armed guards most of the time, most places they go, by the way. So do they get to choose for you that you can't ever have the chance to defend yourself? Second Amendment's not about perfection or safety. It's about you just having the right to fight back. That's it. Do you have the right to fight back or not? It's not going to guarantee any outcomes. But I can guarantee the outcome, if we continue to have these crazy mass murder empowerment zones, there will be more mass murders in those zones. It's going to happen. I've been predicting this consistently year after year, and every year I'm right. For 20 years I've been predicting it, and it happens. Watch the news, it will happen again within the next year in some place where guns are not allowed. Thanks. Thank you.
So now I'd like to invite you both up here, and then we'll entertain questions.
Podium?
Yeah, go ahead. Sure. You're both up here. Any questions for any? Go ahead.
Sure, I guess I would just ask if we were in theory to have more metal detectors, armed security in more of those private places, would we still necessarily have the need to carry on us if we had designated protectors in those areas that were surveilled?
You're asking, okay, yeah, so I'll take it first. Yeah. You put it this way, I am what the dean referred to as an extremist on this issue, because of the simple practical matter that you can't make guns go away. So once you accept that fact, that guns really, we are surrounded by guns all the time, by the way. We really are. You're surrounded by guns all the time everywhere you go. We've got almost 1 million concealed pistol licensees in Michigan. We've got a bunch of cops in Michigan, hundreds of thousands, I think, over the whole state. And we've got a lot of bad guys carrying guns too, right? So everywhere you go, you really are surrounded by guns. You go to a mall, chances are there's 2 or 3 people at least, even in a small town mall, carrying guns. You just don't think about it, right? So once we're surrounded by guns, yeah, so I'm the extremist. I think all regulations are counterproductive and empower criminals. But I don't feel bad about it when I go to court, because I know they've got armed guards and metal detectors. So nobody on my side, and I'm kind of on the extreme on this issue, I get that. Nobody on my side is going to argue with you saying I can't have my gun in a place that has guards and metal detectors.
As a Second Amendment matter, it might make a difference to sensitive places regulation. That's sort of goes back to what I was suggesting earlier, which is we don't know what the standard or the test is going to be for what a sensitive place is. The court hasn't told us. The reference to it in Heller was quite vague, I think is based on some history, right? The court didn't spell out what the history is, and maybe it'll do so in the New York case, and maybe not. But one of the suggestions is as you increase security at a particular location, the risk assessment changes, right? Because the idea is, even though a person may generally have a need for armed self-defense just about anywhere, that need is reduced in a place where there is, fortification or some additional security, right? So having magnetometers or something like that might potentially alter the understanding of sensitive places. My concern with that, though, is what's that going to look like in litigation, right? I mean, are we really going to ask judges to assess whether each individual place that the state thinks is a sensitive place really is? And are we going to involve judges in evaluating how good the security is there on an individual case? I mean, I can imagine. I mean, we do a lot of case-by-case kind of tests in constitutional litigation. I can imagine that happening. I'm just not sure that that's I'm just not sure that's an appropriate role for judges to play.
Thank you.
Anybody else, questions? Go ahead, then we'll go to Dean Miller.
So, with schools in mind, schools, I would say, are considered a sensitive place of guns. With school shootings happening, you mentioned, Ron, that criminals don't care. They don't care. They're going to do what they're going to do regardless. Do you feel that if teachers were to carry, that it would make school a safer place, not only for themselves, but to protect the students as well?
Again, I will not categorically reject that idea out of hand. I think there is some sense in that. Now, if that were to be allowed, I would want, I mean, talk about regulating, I would want pretty strict standards for training and education, right? But I can see the argument for that. Again, my concern is when you allow someone to bring the gun in, even if you presume that they are going to use it defensively and for lawful purposes, I don't know that you can always guarantee that, right? I mean, that's my concern. And this is an argument that exists outside the school context, right? So yeah, is it possible that in some school shooting situations, having armed teachers might have mitigated the harm or even prevented the harm? I suppose that is possible. It's certainly worth considering. And if I were a legislator and I were doing an empirical assessment of threats and risks, I would absolutely want empirical evidence on that, to the extent that I can get it, right? I just don't know that the Second Amendment requires the state to allow it. And that's my point.
Not much argument for me. I'm not sure the Second Amendment requires the arming of teachers either. But I do think we have an empirical standard, which is in Michigan, we've got a concealed pistol license, right? About 700,000 of us have the license, and we've got 20 plus years of data now compiled by the Michigan State Police that those of us with a concealed pistol license are literally 10 times more law-abiding than the general population. And we present almost no public safety threat. The numbers are vanishingly small of people with concealed pistol licenses convicted of any crime, much less gun crime or violent crime. So I think we've kind of already got this handy standard we can just lift off the shelf and plug into teachers. If the teacher has a concealed pistol license, I'd have no problem sending my kid to that classroom.
Can I just say, and this isn't so much a response, it's just another thought on that. I do have some concerns also about the integrity of the educational environment. Now, obviously, having school shootings implicates the integrity of the educational environment, but I also do wonder about the kinds of impact that it would have on students if they knew that their teachers were armed, that there were guns in the classroom, for example, or something like that. Guns that were readily accessible. I do worry about what that would do to the educational environment, and particularly with regard to some students. But again, this is something that I'm open to hearing arguments about. I would not categorically foreclose that.
Dean Miller?
Thank you. I'm curious as to your thoughts on the distinction between concealed versus open carry.
Open carry is, and by the way, we just hit, as of 2 days ago, we're up to, I think, 24 states have what's called constitutional carry, where there's no license required even for concealed carry, right? But one of my law students actually found, it was fascinating, Seneca, the ancient Roman, there was a quote, and this is where I realized that gladius means sword, was when he gave it to me in Latin, we looked it up and translated it, right? So it was, a sword is never a killer, it's a tool in the killer's hand. And he said, doesn't that sound like guns don't kill people, people kill people? Which is kind of the mantra, one of the bumper stickers, right? And so sure enough, we looked it up and they were debating concealed daggers in ancient Rome, it turns out. Wait, so they were debating gun control before there were guns, right? So the theory is open carry of swords or guns allows the rest of us to respond accordingly. We can choose to leave if we don't want to be around the gun, or we'll be able to keep an eye on the person if we see the weapon. But hiding it is something that requires a license, because hiding it allows you to do sneaky stuff, basically. And that's, in a nutshell, the argument that's been going on for whatever, 3,000 years or so. So that's the legal distinction. Is you need the license to conceal. You don't need a license to open carry, particularly in states like Michigan. Article 1, Section 6 of the Michigan Constitution says everyone has a right to keep and bear arms for defense of himself and the state. So there's a clear, and bear means carry, right? So, and we didn't even get into that in the Second Amendment, but bear means carry. So you have a right to bear a gun for self-defense under Michigan law, and so therefore you can open carry with no license, but you need a license to conceal. That's where we're at. I'm not sure if I answered your question.
I don't have any particular response on the distinction between the two. I will say the history on regulation of open carry versus concealed carry is all over the place. All right? It's very, very difficult to discern when you look at the historical legislation starting around the time of the American founding and into the 19th century. It's very, very bizarre, the court rulings on concealed carry versus open carry. Carry, though, is interesting. I agree. Carry bear means carry, which is why, as I said earlier, I think the court is going to have to determine that the Second Amendment extends outside of the home, because it's simply difficult to understand some of these other Second Amendment concepts unless you also understand carry outside the home. For example, if the Second Amendment didn't apply outside the home, why would you need to even discuss sensitive places? Right? Like that discussion would be completely irrelevant unless guns were allowed outside the home. And I think considering the meaning of the word bear as carry also implies that guns are protected outside the home. So I do think the Supreme Court will, if it doesn't in the New York case, it will at some point say that. The reason that I mention that, the reason I think that's an interesting thing to bring up is because for a while now, the Second Amendment has been understood under Heller as applying only in the home, right? There are repeated references in the Heller opinion, which was written by Justice Scalia. Repeated references to the home, protection of hearth and home, right? Self-defense in the home, confrontation in the home. And so that led some to wonder, well, okay, if the court is repeating that the Second Amendment is designed for the home, does it even have any application outside the home? That's where this litigation comes in. In case anyone was wondering why we're even arguing about this, that's why.
Professor Cohen, go ahead.
Well, I think I've actually got two questions. One would deal with what type of civil liability might attach to a victim of a bad event in a sensitive area. That would be one question. The other question is standard ground law in relation to the necessity of self-defense.
I'll take the stand your ground portion of it. So stand your ground, lots of states have stand your ground. Not every state has stand your ground, but lots of states have a version of a stand your ground self-defense law. Stand your ground is controversial for a lot of reasons. What stand your ground is, really, at its core, at its base, what stand your ground is, it is a legislative rejection of the retreat doctrine under common law self-defense. So all that I discussed earlier about the common law doctrine of retreat, stand your ground gets rid of that. Because stand your ground says you do not have to retreat when you are in any place where you have a lawful right to be, and there you can use deadly force in self-defense. Okay? So lots of states today have that. That was not the common law of self-defense, right? That is an evolution of the law of self-defense. But I would argue that that was not the law at the time that the Second Amendment was adopted, and so that is not the law of self-defense that would have informed the meaning of the Second Amendment.
Here's the thing about duty to retreat. It gives the prosecutor two bites at the apple. The prosecutor can admit that the bad guy was trying to kill you, but still prosecute you for defending yourself. by saying, well, in our opinion, you didn't retreat sufficiently before you defended yourself. And on a practical level, I mean, I talk about the Second Amendment a lot, and I'm fond of saying it's not just the law, it's a good idea, right? Kind of like gravity. It's not just the law, it's a good idea. It keeps things where we put them. Well, the good idea part of stand your ground is, it turns out it's a terrible idea to turn your back on a deadly threat. That's one of the first things they taught me at Fort Benning. You don't show your back to the enemy, right? So, and there's another practical issue with stand your ground. The late great Colonel Jeff Cooper said, criminals should fear their victims. And criminals aren't taught anything by victims who run away. So the idea is sort of philosophical. If you have a right to be where you are, and the stand your ground laws are generally limited to, you have to, in order to invoke it, you have to be not engaged in a crime and be somewhere you have a right to be, right? So as long as you're somewhere you have a right to be, why should you have to turn your back before defending yourself, right? The law of self-defense still demands that proportionality, absolutely. So I can't kill you unless you're trying to kill me or rape me. That's it. We're limited to those two circumstances for using deadly force. But if you are trying to kill me or rape me, why should I have to run away first? Why can't I just defend myself? Why do we make the criminals scared of the good guys? That's another question that arises here. So, but all we did in Michigan, you're absolutely right. All we did in Michigan, we just took away the duty to retreat. It's like there's literally a version somewhere out there with a line through the duty to retreat in the statute, and then the new statute just did away with it.
Yeah, that should be clear. I'm not defending the duty to retreat. I'm simply saying that was the common law of self-defense. That is the law that I believe would have influenced, or that would have been known to those who wrote the Second Amendment. So if you care about the original understanding of the Second Amendment, and if you care about the original understanding of the law of self-defense, that is, however undesirable or unsatisfactory that law is, that was the law of self-defense.
Did we answer both your questions?
Other question was on civil liability, if we've got time.
Yeah, we have 4 minutes.
Basic concept that applies, I think we're going to agree on this, is called assumption of the risk, right? So if I walk into a place with a big no gun sign and I leave my gun in the car knowingly, I can't sue anybody for whatever happens by the intervening superseding cause. I could teach you guys 3 weeks on that, so could you. It would be the bad guy is responsible, not the place that put up the no gun sign. If I choose to go in there knowingly, probably, right?
Thank you.
Any more questions? We have a few minutes. Oh, you look like you want to ask something. Go ahead.
I can take a good lawyer joke too.
I got one.
Go ahead, Forrest.
All right, so now, what do you think is the right age for parents to teach their children how to use firearms? What do you feel like is do you feel like there's a such thing as being too young to learn?
To learn? No, I really don't. I started learning when I was 3, and my dad had both his hands on me the whole time. And as a result, I'm partially deaf now, by the way, because Dad didn't believe in earplugs like I do now. I started teaching my daughter when she was 4, and she's a decent shot. We're going to go kill some turkeys here in May. And she's 7 now, so I really don't think they're too young to teach. They're too young to leave unsupervised. And I think anybody would agree with that. And that depends on the kid, honestly. I've actually had a court case that's been going on for years because we've got 2 kids and divorced parents arguing over when can the kids go hunting with dad. And the kids are different, and that's relevant to the judge in this case because the one kid's clearly far more responsible. So simply setting an age, even for these 2 sisters, doesn't really work, right? So that's really, I think, case by case.
Yeah, I don't have a position on the age. I'm from Southern West Virginia, and I grew up in a pretty strong gun culture in Southern West Virginia, and I'm used to seeing a lot of young people with guns, right? For hunting or whatever. So I don't have a position on the age, but I agree. Supervision, training, education, that's the key.
We have time for one more. Go ahead.
So we talked a lot about individual self-defense, but is there a distinction legally in terms of someone who carries a gun who is in a situation in which they might need to defend someone else or another group of people?
That's interesting. There is a concept in the law of self-defense known as defense of others, right? And it's recognized. I mean, it's not just a made-up thing, like it's a recognized doctrine. The thing about defense of others is, ordinarily speaking, you can only defend another when that person would have had the right of self-defense. So it's an alter ego type of principle, right? You are standing as the alter ego of the other person that you are defending. But yes, third party defense of another, as we call it, that is a real thing.
Philosophically, I actually read one law review article that said that you are not defending the other person, you are exercising that person's right of self-defense for that other person, which is a distinction that doesn't make a difference, in my opinion, because I'm a practical guy. So here's how I teach it when I teach the concealed pistol license legal lesson. If you're going to defend another person, you jumped into his shoes for that moment. So if he could have shot the bad guy, then you can shoot the bad guy. Yeah. The other thing we teach is you don't have to yell freeze, get down, do it now, or any other fashionable phrase. You can just execute the bad guy. But action invites reaction too. So the other thing we teach in the concealed pistol licensing legal section is avoid pulling that trigger if at all possible. Because once you squeeze the trigger, your life changes forever. Psychologically, legally, and financially, you're a different person the moment after you squeeze that trigger. So don't do it unless you absolutely must. And that actually is very similar to the old duty to retreat, but we say you don't have a duty to turn your back because that's not the law anymore. You don't have a duty to turn your back on that.
Thank you. Please join me.